Good morning, counsel.
Good morning, Your Honors. Judith Meisner, representing the appellant Charles Dyer. This case arises from events at an apartment in Fall River on June 28th of 1991. Mr. Dyer was convicted of shooting and killing Roy Drew and of shooting George Eldridge.
Just as a matter of background curiosity, why has it taken so long for this appeal to be heard?
There was a motion for some time involved in getting the transcripts. I did not represent Mr. Dyer at trial. There was then time for investigation and the preparation of a motion for a new trial.
18 years?
Which was presented the hearing, after the hearing in the trial court, there was no decision for over 3 years.
When did you, so you filed the motion for new trial in 2007? Is that right?
No, in 2003, I believe.
Sorry, I was confused about another case. I apologize. Okay, 2003, and then the decision was in?
Or actually in 2001. The decision was in 2000 and...
$2009 was the...
Nine was the court's decision. The hearing was in 2006.
Okay.
Mr. Eldridge and Mr. Drew were half-brothers. Their half-sister, Janice, had lived with Mr. Dyer for 8 years, and the two of them had a 4-year-old daughter at the time. Janice had taken the child and left. Mr. Dyer was attempting to locate them to talk with Janice about either returning or make arrangements to care for his child. He had made arrangements to meet through Roy Drew and another half-sister. And this apartment was the apartment of Carol Drew, who was the mother of all 4 of these half-siblings. The versions of people's arrival and comings and goings were somewhat varied, but all agreed that in the afternoon, Carol and Janice Drew, George Eldridge, Roy Drew, Charles Dyer, and his daughter were all present in the apartment.
I'm skipping ahead a tiny bit, but is it did the defendant testify that he did not bring a gun to this equation, that it was Eldridge, somebody else had a gun? Is that right?
The defendant testified that the gun was his, that he had had it in the morning, that Roy Drew had gone out with him in the morning, and that at that time, Roy Drew had taken possession of the gun. He was going to try and sell it. So that at the time in the afternoon when everything had gone really bad and the struggle ensued, the gun was not in Mr. Dyer's possession, but was in Roy Drew's possession.
Okay, and so then the struggle was over this gun, but it was initiated, he says, by Roy Drew.
His testimony was that Roy Drew had the gun and used it not to shoot, but to hit him. Right. Below the waist.
Like as a stick or something?
Yes, as a club. And that he, responding to that, grabbed with one hand Mr. Drew's hand holding the gun. That Roy had 2 hands on it, he had one, and that Mr. Eldridge was holding Mr. Dyer's other arm, and Mr. Dyer was being shoved against the wall during this, and that during this struggle over the gun, it went off and shot Mr. Drew.
Now, if I can move you to the jury instructions, let's move through your various arguments if we can. With regard to the issue of premeditation, there was an error plainly with regard to the malice instruction, but why was that not cured by the instruction on premeditation, which required a decision to kill and was mentioned twice, both during the judge's final instructions and again in response to a jury question?
Well, the second formulation of premeditation spoke in terms of time to form a clear intent. Didn't say clear intent to do what. And since the...
But she
I think
had
the word
said killing
decision
before.
to kill.
Yeah.
was used.
Yes, but in the initial formulation.
If you go to page 82, 83 of the appendix,
And after,
page 83, the terms deliberate premeditation imply that the act
is meditated on beforehand sufficiently long to form both a clear intent and a purpose to carry out that intent.
Or if you look above it, though, the sequence
Yes.
would be first the deliberation and premeditation, then the decision to kill, and lastly, the killing and furtherance of the decision.
Yes, I'm saying you have ambiguous instructions. You have one that speaks specifically of intent to kill. That's then followed up by an instruction that speaks simply of a clear intent and a purpose to carry out intent, and the jury was instructed on different, on three prongs of malice.
But in context, isn't it clear that the judge is talking about an intent to kill?
I frankly am never quite sure what is clear in first-degree murder instructions.
That's a
But-
fair point, but in the relative world,
And what I'm suggesting is that because you have instructions that can be viewed as correct, instructions that can be viewed as incorrect, and you don't have any final summation saying, this is the one you should follow.
Yeah, but we have a rule that says we read the jury instruction, we construe the jury instruction in its entirety, and it seems to me you're pulling out a phrase
I guess I'm
out of context.
suggesting that in its entirety you have ambiguity, and where you have ambiguity, then it's not clear. And
So you're saying that it's not clear from this instruction that the judge was talking about an intent to kill?
from the first paragraph on that page, yes.
What else could she have been talking about?
Well, she also instructed about intent to inflict grievous injury, grievous harm, grievous bodily harm.
but she begins on page 82 of this whole discussion of premeditation, and she says, I'm talking about, there's the first degree is that the further element must be proven deliberate premeditation. The Commonwealth must prove beyond a reasonable doubt that the act of killing was done with deliberate premeditation. And then she goes on and talks about that. So isn't it all in the context of killing?
The parts of her deliberate premeditation instructions are the last part, which is simply talking about clear intent, is not, and that's followed up by a referral to malice, which she described as having three prongs. And
Now, if I can turn you to the voluntary manslaughter issue. I gather that for the jury to have found voluntary manslaughter, it would have had to reject both the Commonwealth version of events and the defense's version of events, correct?
I believe that there is provocation.
Right, but I put that aside. I mean, I gather that he said that he was struck, the victim struck him in the belly with the gun. So there was at least a sudden combat here. So put that aside. But what he testified to, I gather, was not that I got so angry at that I lost it and fired at him. He claimed it was an accident.
Yeah, he testified, he did testify to being upset.
Right.
And so I think that you could view the evidence in different ways. Yes, he was also he testified that this was a struggle over the gun and that it went off accidentally, that he did not intend to do that. It was, and so in that sense it was an accident. It's also self-defense in terms of he was attacked by Roy Drew and was responding. And it could also be viewed by the jury as, I got so mad, I was provoked, and my actions caused the death.
But for the jury to believe that, they would have had to reject his they would have had to accept his version of events that he was struck first, but rejected his version of events that the gun went off when he was pushed by Eldridge.
Yes.
While holding the gun of the victim. So the jury would have to take bits and pieces of each of the cases. I mean, of each of the defense case versus the prosecution case.
Yes.
Now, as to that, the jury was told that malice is negated by the elements of heat of passion. So how could the jury, I mean, I know that there are instructions which are wrong here. We have the Acevedo error. But tell me why the instructions with respect to malice being negated by heat of passion would not be sufficient to correct that error.
Well, again, you have a correct instruction and an incorrect instruction and no resolution as to which the jury followed, then you cannot assume that the jury followed the correct instruction. I think that's what this.
But we're dealing, of course, here with a case in which there was no objection to the instructions. So we're dealing here with a miscarriage of justice standard.
Yes, and I'm suggesting that the totality of the totality of the errors in the charge rise to that level.
Now, does it matter that this was not the defense argument in terms of evaluating whether it constitutes a miscarriage of justice?
I think that the defense did request a
I know it requested it, but
instruction.
does it matter that this is not what the defendant, that voluntary manslaughter is not consistent with what the defendant said happened? Does that matter in terms of our evaluation of whether it's a miscarriage of justice for the instruction to have been
I don't believe
muddled?
so. I think that if the court instructed the jury that this was a permissible defense and gave incorrect instructions or ambiguous instructions which the jury could not necessarily resolve, that does still factor into a miscarriage of justice standard. The self-defense instructions also, I believe, are part of the error, particularly the refusal to give or the failure to give a non-deadly force instruction.
Yeah, that perplexes me a little bit because if the jury, I mean, I understand that if the jury accepted his version of events, that according to him, he did not use deadly force.
Correct.
But if they believed that, they would also have found it was an accident, not that it was a shooting. I mean, for to find voluntary manslaughter, they would have had to reject his version of events and found, yes, he was struck, yes, there was a struggle, but then he, in anger, fired the gun, which would be deadly force. So I don't get how pragmatically it matters that there was no non-deadly force instruction.
Well, if you are talking about reasonableness and what you would reasonably do, if it's non-deadly force, you have to have a reasonable concern for your personal safety rather than an imminent danger of death. So if you're struggling over a gun that has been used as a club, then what you need is a fear for your personal safety, and it's a lower standard. And by failing to give a non-deadly force instruction, essentially reduced the Commonwealth's burden of proof, or the Commonwealth's burden on self-defense.
But are you saying if you'd had a non-deadly force, I guess I'm asking the same question as Justice Gantz, but if you had a non-deadly force instruction and you obviously have the jury rejecting an accident in this case because they didn't find that, what would that end up with in your view, given that the jury rejected an accident here? What could have happened if the non-deadly force instruction had been given?
Well, we don't know what the jury precisely what the jury did or didn't find in terms
Well,
of
I'm
the
just
facts.
suggesting that it
But
didn't find an accident because it didn't acquit
Right.
your client. Right.
But perhaps the jury would have viewed the back and forth differently if it had been instructed that the defendant had a right to respond at a lower level. The jury could have felt that that his response in grabbing a gun was unreasonable if it had to be a question of imminent bodily of imminent danger of death because he hadn't been shot, that it had just been used as a club. So,
I mean, they might have thought that he should have had no response to this club being used to him. Is that? Maybe I'm just not understanding.
if the, you mean, without a deadly force instruction?
If one had been given, I was just
Without a
trying to
non-deadly force instruction.
hypothesize what result could have happened if one had been given. I mean, what would you have argued if one had been given?
That his grabbing the hand with the gun was not an unreasonable response because while he may not have had a fear of imminent death from the use of the gun as a club, he did have a reasonable concern for his personal safety from the use of the gun as a club.
And then I take it you would say, and if he grabbed the gun and even if he shot it didn't accidentally go off, but even if he shot it, that would still be part and parcel of that. Is that?
Yes. I'd like to address the two issues. The new trial motion, the failure to investigate and to present an expert, and the public trial aspect. In terms of the investigation, as described at trial, you had a detective who was the crime lab technician, a state trooper who was a ballistician, the forensic pathologist who performed the autopsy, and the doctors who treated Mr. Eldridge. They essentially testified that they recovered projectiles from the floor and from the side panel of the kitchen cabinet, that they saw bullet holes in 3 places, but that they did not, there's no evidence that they had preserved any of these pieces, any of these areas where the bullet holes had been observed. Mr. Drew's autopsy was photographed, including the clothing. There were no tests done for the presence of gunpowder, and there was no evidence that the clothing had been tested. There were no pattern residue tests by the ballistician, which would indicate a muzzle to target distance. And there was no forensic expert called by the defense at trial. Now, defense counsel indicated that he that he's planning to argue the inadequacy of the Commonwealth's investigation, but the court said, no, you can't because you didn't go far enough in setting up an adequate predicate. After trial, there was a forensic expert, Dr. DeForest, who examined the transcript of the testimony of the shootings and of the investigation and reviewed the exhibits, and he submitted an affidavit in support of a motion for a new trial.
But I mean, I know you're running short of time, but that's the fundamental problem, isn't it? Is that you have the expert looking at what occurred at trial, knowing all that the defendant testified to, saying they should have, on the day of the shooting, anticipated all that the defendant testified to and done all these tests to negate that, but the Commonwealth says, how are they supposed to know that that was going to be the defense? Why is it reasonable to spend all that money to address a defense which they had no reason to know would be presented?
I suggest it's not all that much money to preserve evidence so that it can be examined at a later time. And that, in part, the trajectory analysis, for example, could have been tested or examined later through examining preserved evidence. And if the trajectory analysis supported the defendant's version of the shooting of George Eldridge, for example, where Eldridge and Janice Drew said that the defendant was standing on top and pointing down, and Mr. Dyer testified differently. If his testimony had been supported, that could not only have affected the verdict on that count, but affected the way the jury viewed the testimony as to the events involving the death of Roy Drew.
Your time is up.
Thank you.
Good morning. May it please the Court. William Conley for the Commonwealth. Your Honors, as to my sister's first point, I think the panel has made it clear that that there was no ambiguity once the judge instructed on deliberate premeditation. The intent to kill was, in fact, I think it's about 16 lines later that she discusses the specific intent to kill being necessary for deliberate premeditation, which would not mislead the jury in that regard.
But why don't you turn to the voluntary manslaughter? That doesn't have quite the clarity of the deliberate premeditation.
With regard to that, Your Honor, first position would be that was not warranted.
Yeah, I didn't understand that. I mean, the testimony that if you credit his testimony, which I know you don't, but the jury would be entitled to, the victim pulls out, who knows where, this huge gun, strikes him just above the waist, causing Dyer to double over, and then Eldridge comes at him. I mean, how would that not, at the very least, be sudden combat?
Well, that there was no testimony that would indicate that that it did produce in him at that moment such a state of passion, anger, fear, fright, or nervous excitement that would eclipse him.
When a guy strikes you in the stomach with a gun, causing you to double over, isn't it a fair inference that generates a certain degree, at least, of anger, of pain, of
maybe self-defense, but not as to provocation, Your Honor. And our position is that was not present.
So he has to articulate that? Is that what
he didn't at the time of trial.
No, but are you saying that he has to articulate it?
There has to be that one of the predicates is that to get such an instruction on the provocation theory, there must not only be evidence that would warrant a reasonable doubt. I'm quoting now from.
So what did he say he did as a result of being struck in the stomach with a gun?
It was very matter of fact. There was no emotional, no statement of anger or any of the other indicia. It was he demonstrated for the jury, I believe. I grabbed him like this, and this is a loaded gun, by the way. It was his gun. He realized that. He brought it to the scene. He brought it to the area, assuming even his testimony. And he grabbed the gun, grabbed the hand of the victim which had the loaded gun, and this was a cannon by everyone's description. In fact, the defense attorney called a piece of field artillery. And that was, according to him, that would be the struggle. It was a matter of fact of this happened, that happened. There was no indication at the moment in question that would have indicated satisfactory provocation to warrant such an instruction.
In the whole scene where they're disagreeing and fighting and arguing and nothing, you don't think that one could draw a reasonable inference of provocation there?
The goings back and forth of sitting down, what happened in the apartment beforehand, were well in advance of this sudden, if you will, according to the defendant, attack upon him. His feeling foolish, I think, or his being upset I believe it was the brother's reaction to the videotapes. That happened substantially before this event because I think it showed another tape, and then there was a discussion back and forth. So it was remote in time and not at the moment that would be in question.
Okay, well, put aside a reasonable provocation. Why is it not a sudden combat?
Well, if it according to him, it would be sudden combat.
And that's enough to get you the manslaughter instruction.
But if that would be a possibility.
Okay, so let's assume for the moment that he was entitled to it. Tell me why the instructions are clear enough that we should view them not to be a miscarriage of justice.
Because when you look at the initial statement by the judge dealing with differentiating between manslaughter and murder, and what we point out to be the last statement, if you will, which Your Honor mentioned earlier about negating malice is negated by provocation. Interspersed there was the correct statement of the Commonwealth's burden. Between those three, it would be evident to a jury to know that for the Commonwealth to prove manslaughter, that it must prove that it was not done with reasonable provocation. With regard to the forensic expert, the exchange or the reference that my sister made to defense counsel in the Bowden defense, I believe when you look at the transcript of that, there was it would be appropriate to consider the exchange as having been between the judge and the prosecutor with regard to what the prosecutor could not argue in final argument, as opposed to what my sister has indicated, the defendant has indicated, an admission, if you will, by defense counsel that I should have asked that next question. I should have asked the final question. It's not clear that that is what my sister is claiming. It's more indicative of an exchange between judge and prosecutor, and a statement by defense counsel at the end.
Well, I'm going to stop you there. I had thought it was the defense counsel there was some discussion with regard to arguing the failure to do tests to indicate how close the gun was when fired, and wanted to argue that there were no tests done, and the judge said, well, you didn't show what those tests would have revealed, so how can the jury infer that those tests would have had consequence, and because you didn't do that, you can't argue it?
That's correct, but I believe that's an exchange between the judge and the prosecutor.
Would it matter?
Yes.
It was a defense lawyer who wanted to argue it, I gather.
Well, but the exchange that in question is I mean, the statement by the defense counsel that we're talking about came in context with this exchange, if you will, and our position is that it was not part of the exchange. The exchange was between the attorney, between prosecutor and the trial judge.
And why should it matter
because
who said it?
Because
if it was defense counsel who wanted to do it.
Because it doesn't make any sense, and there's not really a reason for it to be said. It doesn't apply to what we're saying is it doesn't apply to what was going on. So it's just a statement by the defense counsel.
Put that aside. Why do you say that the failure to offer that evidence? I mean, it did deny the defense the opportunity to give a Bowden defense.
Well, but as we point out, the defense was essentially non-existent. This was at the motion of a new trial and on appeal. The defendant is discussing his trial counsel. So on page 20 of the brief is discussing trial counsel inaction, if you will. And trial counsel was appointed a year and a half after this. And the facts are that the police were faced with a situation, as the brief points out, that it was everything was there for them. There was no reason for them to test the hands of the victim. And even initial counsel wasn't appointed until a month and a half. The defendant wasn't apprehended until a month and a half later. So the victim is long buried by that time. It just was not a viable defense to put forth. And looking from the point of view as to when it happened, as opposed to at trial, an event that happened in 1991, trials 1994, and for the first time, defendant is coming up with is stating what happened. The point I want to make one point also with regard to the trajectory aspect that my sister pointed out. The defendant, rather George Eldridge, who was shot, testified that the defendant shot him while he was prone on the ground. And my sister suggests, I think in the brief, that the trajectory of that would have been an important aspect. However, that bullet remained in George Eldridge's shoulder or body. It was not taken out. So it was not there there was no such trajectory to be considered at that point. Unless there's any further questions?
Thank you, sir.
Commonwealth rests on its brief. Thank you.
Mr. Connolly, I just have just one point. Do you know why the trial transcript wasn't prepared within 2 years of the trial of this case?
No, I don't, Your Honor. All I know is, as pointed out, the verdict was in 1994, and the motion for new trial was filed in 2004. And there was just almost 10 years from one to the other.
Was the court stenographer, this isn't the case where the court stenographer later became employed by the DA's office, is it?
I don't know. I know who the individual is, but I'm not sure if she was, I don't have
Okay.
the copy of the transcript.
Thank you.